All right, we are green. Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors, the place where we not only talk about what's going on in the gun world, this beautiful country, and how we're going to fix both of them together. Today, we have some breaking news that dropped around 21 minutes ago. The FPC account on Twitter just announced that the 7th Circuit has said, about that AR ban unconstitutional overrule. Yeah, we're going to have to stay the ruling that says it's bad, and we're going to have to say, let's just keep it as status quo, because, status quo is so peachy. I'm going to show you everything right now. Everything's always linked per usual. Make sure you hit that like button, subscribe to the channel, turn the notification bell on if you guys are just getting in here. Make sure we are 5x5, and as you get in, we will start driving home with what's going on coming out of the 7th Circuit around the AR bans. As one step closer to the SCOTUS we draw. This is going to be something right here. All right, we are 5x5 in the chat. You guys hear me? You guys see me? Let's get to the lead. No need to bury it. This probably won't be a super long video, but I want to show you what FPC just put out coming out of the 7th Circuit. So, FPC legal update. The 7th Circuit has granted Illinois' motion to stay the district court judgment in our lawsuit challenging the state's assault weapon and magazine bans, which means the law will remain in effect while the appeal continues. Now, that's the big piece, and then I'm going to show you the actual document. I'm going to zoom in. While the appeal continues. Now, this is not a big surprise that the higher court in Chicago, the 7th District, is going to say, no, AR bans are cool. They've done it for years. That's not the big story here. The big story is, now you got a 7th Circuit, now you got New Jersey, now you got Maryland. You got a whole lot of AR bans that are working their way up with pretty fast ferocity. And we're going to hear one that's been distributed for conference here in the next, I think, 8 days. This is coming to the top, guys. And this is just another step in that process. But let me show you this. Like I said, it's probably not going to be a super long video, but let me dive in here. This is from the United States Court of Appeals for the 7th Circuit, as you can see, dated December 5, 2024, right there. There's a few things in here I'm just going to read really quickly. I'm not going to move the screen just because some of it's kind of dumb. Here's the actual order. Listen to this. The district court issued an opinion holding that multiple state laws regulating assault weapons, large capacity magazines, and associated matters are unconstitutional. That's because they are. Just saying. The opinion contains some language in the nature of a permanent injunction, but this language does not appear in either an injunction, in either. An injunction must state the reason why it's issued, because it's unconstitutional, it's pretty simple, state its terms specifically, and C, describe in reasonable detail, and not by referring to the complaint or other document, the act or acts restrained or required. So it sounds like, well, we didn't like the way you did it. But let me get to the end here, because this is the important piece. Of course, they went for the appeal from Illinois like we knew they were going to. This part right here, where they start relating to other cases that are going towards the SCOTUS, guys, this is the payoff. We're not squabbling about these one little twosy states. We're talking about the whole enchilada. We're going SCOTUS on this, okay? You got the New Jersey case, you got the Maryland case, and now you got the Illinois case. They're all going the same direction because they overstepped. Check this out. If you're just now watching, the 7th Circuit said AR bans are here to stay because it's basically a stay on the unconstitutional ruling. But anyway, here's from the actual ruling itself, the order. Defendants' request for a stay, this is the state of Illinois, rest largely on the fact that this court already has held that the laws in question survive motions seeking preliminary injunction. So they're saying, we already talked about this. A decision at the preliminary injunction stage is not dispositive when the plaintiffs later seek permanent relief. Our opinion indicated some matters that needed further exploration. Yeah, like the unconstitutionality of the entire dang thing. They're talking about the PICA Act in Illinois, if you're not familiar. But the analysis in Bevis shows that the laws have enough support to remain in place pending the final resolution of plaintiff's suit. Again, angling upwards. This part right here is the other Court of Appeals decisions. Every other Court of Appeals that has addressed the validity or similar legislation in the wake of the Bruin decision has come out the same way as Bevis. So this is the interesting part. Ray, I'm going to stop just so I can know where I am. Their argument here is that every other court case that's come out after Bruin, which, by the way, none of them have been reconsidered under Bruin. It's just kind of a status quo vibe they keep going back to. They're saying, well, everyone else thinks that AR bans are totally legal. Yeah, because the only place that AR bans are being propagated upon the population are deep blue bastion states. It's kind of like if you were to say, like, a lawsuit, this is so weird, but a lawsuit that says dudes find women attractive, and then in blue states. It's like, no, not all of them. Okay, what? That was a terrible example. Oh, whatever. I'll come up with a better one in a second. But anyway, the point is, all the other states. Now, man, that was a terrible thing. See, that's why live is dangerous, guys. Sometimes you get really dumb analogies that pop out and try to land, and they don't land. Anyway, let's keep going. The laws addressed by those decisions differ in some respects from the Illinois statute, yet the absence of support in other circuits of the district court's disposition lends strength to a conclusion that the Illinois statutes should remain in force until final appellate resolution. Again, that's talking about the SCOTUS. Now, this last piece is so dumb. Man, that was a really dumb analogy. Guys, from the bottom of my heart, I messed that up. At least 2 other essentially identical suits are pending in other district courts within the 7th Circuit. The 3 suits were addressed jointly in Bevis, and they must be resolved the same way eventually. This does not necessarily imply that the 3 cases will again be consolidated on appeal. We are reluctant to delay disposition of this appeal indefinitely just because similar litigation is pending in other districts. Still, the only way to preserve the status quo statewide is to enter a stay in the suit. So what they're saying is, well, we don't want to damage any of the status quo of gun control. That would be horrible. I would feel so bad about that. So what we're going to do is, in light of the multiple cases that are saying this is all unconstitutional, we're just going to go ahead and say all of it's constitutional because the status quo is so crucially important for the state. So we're going to go ahead and keep that in place until we get to the end result of this, in which case it's going to be unconstitutional. But at least we preserve the status quo. The status quo is quite literally an infringement upon the rights of Illinoisans across the board, but it's the status quo. We don't want to upset the apple cart. Maybe you shouldn't pass unconstitutional laws. I don't know. Just call me crazy. The judgment of the district court accordingly is stayed. The stay will remain in force until this court has issued its mandate. And I'm just going to go back to the FPC thing real quick. This is the entire point, guys. They pass unconstitutional laws that infringe upon the natural rights of the individual and the citizenry. Then, when they try to get them overturned, you go, well, you can't upset the status quo. But you upset the status quo when you pass the stupid law. But, now that it's in place, you can't upset people. Yeah, that's the entire point. Let me jump in here really quick. 7th Circuit Judge's lunch. Oh, I don't know. Oh, I do get it. I can't read that, S-man. You're crazy. I am crazy. It happens like that sometimes. If you guys are just now getting in here, okay, you guys are crazy. FPC just put out the legal alert that basically says the 7th Circuit Court of Appeals has said the AR ban unconstitutional ruling can't stand. They basically put a stay on it. That's what you're talking about. Are they going to move to state to Canada? I don't know. Let's see what you guys thought about my funny little example. Looks like you guys just kind of kept on trucking. You are a 2A hero. I appreciate it. Even with my really bad example of dudes liking chicks, I'd be like that sometimes. Cool. So guys, that's what we've got right now. Short video. Just wanted to bring it to you. I'll have another one coming out later tonight. But I hope you guys enjoyed, and I'll see you on the next one. I'm Braden.